Council. Welcome to the Minnesota Judicial Center for oral argument before the Minnesota Workers' Compensation Court of Appeals. Today's date is December 13th, 2024, and we have one case scheduled for oral argument, Jermain English versus Reliable Property Services, LLC, and XL Insurance America, Inc., as administered by Helmsman Management Services, LLC, our file number WC24-6571. I would remind counsel today's argument is being live streamed and recorded. We would ask that when presenting your argument to the court, you speak loudly and clearly. The panel for today's argument are to my right, Judge Sean Quinn, and to my left, Judge Catherine Carlson, and myself, Tom Christensen. We have experienced counsel present today, and as a reminder to each counsel, you are allowed 15 minutes to present your argument with a yellow light going on when 2 minutes of time remain. Please be aware that we will allow 3 minutes of uninterrupted time before I ask the panel if they have any questions. At that 3-minute mark, I will interrupt your argument wherever you are, and again, ask the other judges and or myself if we have questions for you. Counsel are asked to keep track of their time and may reserve any unused time for rebuttal. Should the allotted time to a party be extended because of questioning from the court, I will extend a courtesy to opposing counsel that same amount of time. When you step to the podium, I'd ask that you identify yourself and the party you represent. And Ms. Tuft, I believe you're up first today. Good morning.
Good morning, Your Honors. May it please the court and counsel. I'm happy to see you all on this brisk morning. My name is Christine Tuft, and I represent the employer and insurer in this matter. We, on appeal, have presented 3 primary issues to the court. Primary liability based on a prohibited act offense, average weekly wage issues, and maximum medical improvement. So I'm going to address each of those issues briefly before I take your questions. With respect to primary liability, it's our position that the judge failed to apply the correct legal standard to the issue and analysis of primary liability. With respect to the average weekly wage issue, it's also our position that the judge failed to provide or apply the correct legal standard on the average weekly wage. And in fact, we think he conflated the concepts of on-call employment with seasonal employment, and also conflated applying both seasonal employment and irregular employment analyses to the average weekly wage issue. And then with respect to maximum medical improvement, likewise, we're arguing that the correct legal standard was not applied, as there's no evidence that there is any anticipated significant lasting improvement that might result from the any ongoing treatment, and that the case law and the statute and the rules all indicate that the mere fact that ongoing medical treatment is recommended is not a barrier to a finding of maximum medical improvement. So that's our overall general position on all of the issues before the court. I'd like to spend a little bit more time on the average weekly wage issue. And I think it's significant to note in this matter that Mr. English testified that he was an on-call employee, that he only worked when he was called in to work, and that was for snow removal. And it's our position that that on-call employment does not equate to seasonal employment. We acknowledge snow removal only happens, 9 months out of the year in Minnesota. But it's our position that on-call employment should not be treated the same as seasonal employment. And in fact, I think the case law supports that analysis as well, that the case law indicates that seasonal employment is something that would occur every year at regular intervals. That's the Neubauer case that indicates that. So it's our position that here we have no proof that this was seasonal employment. He had last worked for our employer in 2020 when he voluntarily left by his own testimony.
Let me just stop you. We have at the 3-minute mark.
Thank you.
Judge Quinn or Judge Carlson, any questions?
Ms. Tuft, I'm going to pick up exactly where you were talking about the on-call versus the seasonal. Are you saying that you can be on-call or seasonal, but you can't be both?
Right. I do think that under the case law, those are not the same concepts.
But can you have both? Can you be on-call and seasonal?
Yes, I suppose that you could meet both definitions.
So why were both definitions not met?
The concept of seasonal employment here, I don't think is met because under that Neubauer case, the Supreme Court indicated that seasonal employment is something that occurs on regular intervals and on a yearly basis. So in this matter, there's no evidence that any of his work was going to occur on regular intervals because we know that, snowfall doesn't happen at regular intervals. He testified that that was the only type of work that he was going to do for my employer in this matter. And it's not something which occurs for him on a yearly basis. He didn't establish that. And this court's prior precedent talking about whether something is seasonal employment for purposes of including it in an average weekly wage analysis talks about the fact that there must be a showing that it is going to happen on a seasonal basis. So in, I think it's the Welter case, if I remember right, involving a person that umpired softball. I think I have the right case name. I apologize if I don't, but the court found that there wasn't a showing that it had happened, even though the person testified that it had happened for multiple years. There wasn't a showing, there was no evidence produced that it happened at regular intervals on a yearly basis.
Well, this stuff, certainly your office has handled and this court has handled, and I've handled many cases where people are injured on their first season of a seasonal job. So you're not suggesting that you have to show that you returned for more than one season to qualify for a seasonal worker.
Correct. I agree with that, but in the you have to have the whole context of the entire case. And so from our perspective, when you have on-call employment, as we do in this case, it is different than a construction worker who works a construction season. For example, they don't do that on an on-call basis, or they might not do it on an on-call basis. So I think that is a distinguishing factor from some of the case law in which people are injured in their first season of working a particular type of employment.
Along the average weekly wage line, well, I guess this is more of an MMI question. I take it your client, I know your client denied primary liability. I take it your client still has yet to make payments to the employee in light of the trial judge's decision.
Correct, because we appealed the primary liability issue as well.
All right, because I was like, well, MMI doesn't even matter anymore because we're at the pretty much right at 3 years, right about, next month we'll be at 3 years. We'll be at the 156 weeks maximum.
You're correct.
So, but
Yes.
this, okay, so it is relevant. Okay.
It is relevant. Yes, Your Honor. Sorry.
Or not moot, I think. Would be a better way to
Correct.
put it.
And
Correct.
I have a question on the maximum medical improvement issue. At least the last record I saw, the hearing was at the end of October of 2023, and the last medical record I have is from October 17th, 2023. And it appears that the employee was simply asking the medical doctor for more PT because the past PT was the same as the home exercise program. Can you give us any update as to what happened, if anything, in terms of medical care and treatment after the hearing?
Your Honor, I cannot personally, because we've been litigating this case on appeal, so we haven't, I haven't revisited any ongoing medical in this matter, but it's our position that even with that record, that MMI is still established in this matter. The case law on MMI and really the rules, on MMI, when you look at the rule, it specifically indicates that the fact that any additional diagnostic testing is recommended, or the fact that any additional physical therapy in this case is recommended, is not a barrier to a finding of MMI. And I think that's important in this case, because even with those recommendations, we have the employee's testimony that his condition was worsening. And we have the fact that no doctor said any of those diagnostic testing or physical therapy would meet that statutory definition of significant recovery or improvement being anticipated. So even if he had additional treatment, I just don't know. It's not part of the record. I don't think it impacts the potential determination of maximum medical improvement. And we just don't think that the judge, properly analyzed that. Again, I think he conflated the concept of significant lasting improvement with, there's some additional treatment recommendations. Therefore, we don't have MMI, and there's no evidence that there's anticipated significant improvement or recovery in this matter.
I have another question about the average.
Sure.
Okay, and I have more questions, but I'll stick with the wage.
I'm here to answer the questions.
This court in the past year issued the Buckwalter decision, where we discussed seasonal wage and put out the statutory language that the legislature has not changed despite cases where the result has been a higher average weekly wage.
Yep.
And the statute says what the statute says. And 176.011 subdivision 8A specifically says that jobs that are affected by seasonal conditions are considered seasonal employment. Do you agree that snow removal is affected by seasonal conditions?
Yes, and I think I already indicated that definitely it is affected, but.
So my question is how does the on-call nature of that kind of exempt it from this, this very clear statutory language? I understand what you're saying.
Yep.
He was on call, he was also seasonal, but how do we get around the fact that the statute clearly says that seasonal workers should be treated a certain way?
Well, I think there's a couple of things. First of all, just going back to that Neubauer case that I talked about, it essentially said that seasonal employment is something which occurs every year at regular intervals. There's no evidence of that in this case. So that's number one. I don't think that the court is tied to the seasonal employment analysis in this matter, because the case law says that there's just no proof in this case that it is something that it would occur on regular intervals. But secondly, even if the seasonal employment analysis does apply, and I acknowledge the Buckwalter case, my office's case, so I'm very familiar with it, but the Supreme Court has indicated that the goal is to determine a fair approximation of the probable future earning capacity. And here, at best, we have an employee who is working arguably 2 on-call jobs. In the 26 weeks prior to the date of injury, he earned less than $10,000. And the average weekly wage that the judge is awarding him in this case is more than double that. And I don't think that meets the Supreme Court's mandate that we're looking for a fair approximation. So, we have the Koziolak case cited in, our materials. They talk about that fair approximation analysis. The WCCA, it actually was affirmed without opinion by the Supreme Court, but this court pondered in that case whether there was any basis for something other than a literal application of the statutory formula, and it concluded yes, that there is at times when we need to look beyond the statutory formula in order to meet that goal of finding a fair approximation of the lost earning capacity that might result from an injury. And under that case, this court found that strictly applying the statutory method would go far beyond that objective. And it's our argument that the same is true here. That a person that worked 2 on-call jobs, in fact, restricted the types of even on-call jobs he would take from the one employment, testified that he only would work one job if the other job wasn't available, to give that person an average weekly wage based on a seasonal employment analysis doesn't meet that objective of a fair approximation of the pre-injury earnings. So the claimant, in our estimation, failed to produce any evidence of an earning capacity beyond part-time on-call employment, and the judge's determination of a $1,650 roughly average weekly wage.
I'm sorry, I
Yep.
just want to make sure we get a chance to talk about the prohibited act.
Yes.
Argument. Case law from Minnesota Supreme Court dating even back to, I believe, the 1930s, is this theme of there needs to be an unequivocal and specific prohibition
Mhm.
for the prohibited act doctrine to be applied. What did your client have an unequivocal and specific prohibition? And if so, what was it and how was it communicated?
Right. The employer had a requirement to wear seatbelts when operating any of their vehicles. So that's a affirmative requirement that, I'm sorry, I'm out of time. Can I?
Yep, please go
Okay,
ahead.
thank you. So that's an affirmative requirement. I think we can presume that an affirmative requirement means that you are prohibited from not wearing it. But it's our position that we required the wearing of seatbelts. He acknowledged, he knew he was required to wear a seatbelt. He acknowledged that he wasn't properly wearing the seatbelt at the time of the injuries. So I think that.
How was that clearly communicated?
It was in the vehicle that the seatbelt was required. It was in their policy manuals, which he acknowledged receipt of. And in fact, he testified essentially that it was obvious that you should wear a seatbelt. So he clearly knew that there was a requirement of wearing a seatbelt.
Along those lines, and I know you're out of time, but keep going. The Supreme Court in Bartley, I think is the name of the case. Bartley. And I'm paraphrasing, but basically said there's a difference between a prohibited act and a permissible act done in a prohibited fashion.
Mhm.
The former being, no compensation. The latter, there is compensation. Isn't the act, he's operating the machine, and he's just doing it in a prohibited fashion? How do you distinguish that?
Well, I think the distinguishing factor here, in part, is the injuries sustained as a result of performing the act in a prohibited manner. Because we believe that the evidence establishes that had he been properly wearing the seatbelt and not driving in the reckless manner that he was driving, that he would not have sustained the injuries, which are significant in this matter, no doubt.
Speculative, you don't know for sure what his injuries would have been, and what is the evidence that he would not have sustained any injuries?
The IME report of Dr. Dick does indicate that because of not wearing the injury, he sustained the nature of the injuries that he has in this matter. And also, I would note that almost all of the initial medical made a point of indicating that he was an unbelted driver, which, is, I understand, not direct causation opinions, but certainly the fact that they made a point of putting that in their records, I think, is significant in terms of the causation analysis when you then combine that with the IME opinions of Dr. Dick.
Any other questions, given the time? Okay.
I have all day.
Let's do it.
Okay, so you've talked about the unequivocal and specific prohibition of operating a vehicle without and I'll call it a vehicle, I know that's a term.
Yep.
that you said was clearly communicated by various means. Where's the evidence that it was enforced? I know he was terminated after the injury, but where's the evidence that this was enforced prior to the injury?
We don't have specific evidence. I will acknowledge that we enforced him having to wear a seatbelt. He did the job by himself. You can see that from the video that was submitted in this matter. Snow removal isn't something you're doing in a factory where everybody can see that you're violating requirements. But we did submit evidence that the employer does enforce their policies and that they do discipline people, including this claimant, when they don't follow their policies. So our employer, my client in this case, didn't know that he wasn't wearing the seatbelt because he's out there doing the job by himself. But they do have a history, and we believe that we established it through his own personnel records of enforcing their policies. Yep. Yes.
But
Correct.
do we have to have enforcement of the seatbelt policy just and maybe not to this specific employee, but hey, we all know this gets enforced because we do this all the time. Should we have evidence of that?
Well, I think, Your Honor, I think that places an unrealistic expectation on employers to be able to bring in evidence of every time we enforced every policy on every thing that happened. And in particular with people who are charged with working independently on their own. For an employer to have to have additional employees to go out and monitor whether those employees are doing their jobs correctly and in the correct manner, or to require us to have evidence of every policy violation that we've ever enforced. And in fact, I suspect I would have a hard time getting that into evidence in front of many of the judges at the OAH, because they would find it to be irrelevant as not related to this particular claimant. So I think that version of looking at the standard would place an unrealistic expectation on employers.
Any other questions?
Good.
Okay.
Thank you.
Thank you
Ms.
all.
Thank you.
Happy holidays.
You too. Since we went over about 5 minutes, we'll allow 20 up to 20 minutes if you need it.
Sounds good. All right. Opposing counsel, your honors. May it please the court, my name is Eric Nelson. I represent Jermain English, the respondent in this matter. I do have a little bit of a synopsis written up, but I kind of know where the court is going, so certainly you can interrupt me at any time just to talk about the matters that we've been talking about. But to that end, and hopefully this answers some of the questions, I represent Jermain English. He was injured January 21st, 2022 while operating a tool cat to remove snow on Nicollet Mall. He worked for Reliable Property Services. The tire rod on the tool cat snapped, causing the vehicle to spin sideways, and he struck a concrete barrier or planter. This resulted in paralysis, and he suffers from paralysis still today. He was hired back in 2017 and worked up from a laborer to a foreman to head operator of snow removal on Nicollet Mall. And he worked 2017, 2018, 2019, and then all is in the same capacity. So we have a history of him working solely as the head operator for snow removal at Nicollet Mall. So we have a long history of him doing that. We can go back and look, and he testified to that effect. Opposing counsel provided no witnesses to counter that fact. So we have a long history that we can go on of what his tasks were, what his role was when he went in and when he did not go in. He had stated in his deposition, for example, that he had probably cleared snow hundreds to thousands of times on Nicollet Mall in that capacity. He did take a short hiatus in 2020 to take care of his grandmother. And then Reliable asked him back in 2022 to the same exact role, head operator of snow on Nicollet Mall. He was the only employee to remove snow on Nicollet Mall. There were no other options. So if he said, if it snowed, I was working. And if it didn't snow, I wasn't. It wasn't as if the employer and insurer, the employer could call Tom, Dick, Harry, or Jermain and choose which one they wanted to come in and clear snow. It was always going to be Jermain. The employer and insurer then denied this claim, stating he violated what they called a life savings rule. When asked about that rule, that specific rule, or the nomenclature of that rule in the hearing, Mr. English said, "I have never heard of that rule."
You're at the 3-minute mark. Any questions from Judge Quinn or Judge Carlson? Dick?
Morning. Mr. Nelson, I'm going to ask you the same question that I asked Ms. Tuck. Was there an unequivocal and specific prohibition about operating the toolcat without a seatbelt?
No, there wasn't. There was absolutely nothing in evidence. There was no policy, no written policy. There was no witness that was called by the defense, any representatives of the employer that came in and identified this known policy of not wearing a seatbelt. There was nothing in his employment file about not wearing a seatbelt. There was nothing about operating the toolcat at all. In fact, when asked about his training in the operation of a toolcat, he had indicated he had received no training whatsoever and only trained himself by using YouTube videos. And in this instance, I think we have to look to fairness as well. I mean, he's operating a toolcat that is apparently dilapidated. The tire rod snaps in the normal course and operation of it. He's not using it in a crazy manner. It has no rear view mirror. It has no side view mirrors. He has informed the employer well before the injury that it had no mirrors, and yet they didn't change it. And so he testifies that he takes the shoulder strap off of his shoulder and puts it around the armrest so that when he's operating the toolcat, he can see safely behind him by looking over his left shoulder. He cannot rely on any side mirrors. He can't rely on any rear view mirrors. And I think that goes to, the argument is, well, we haven't used this 6-part test on this prohibited act, right? And I don't even think we get there. In fact, we probably shouldn't even do the 6-part test. We should just start at the causation portion. Did this prohibited act cause the injury? We can save a lot of time and energy not even going through 6 parts. There is no evidence in this case whatsoever that if he would have worn the shoulder strap portion, because we will note he wore the lap belt, and the only reason he removed the shoulder strap is because he couldn't rely on the equipment that was provided him to see behind him. So he removes the shoulder strap, and therefore now he's under some sort of prohibited act. Back to your question, there was never any policy about you have to wear your shoulder strap when you're operating the toolcat. It's not a motorized vehicle. They knew when he was hired he had no license. In fact, we had provided information to the court, evidence that says that he was hired as a non-driver. They knew he did not have a license. So he could not operate motorized vehicles.
Let me interrupt you. The transcript supports what Ms. Tuff said, that your client said, well, it's common sense.
Mhm.
So even if it was not a specific prohibition that was clearly communicated to your client, it sounds like he understood
Sure.
that it would be common sense to wear it. How does that factor in, just kind of the common sense argument?
Well, it factors in because common sense is not the law. The law is there a specific prohibition against this act? Not whether or not you in using common sense or, using the best of your ability knew. I mean, we're talking about a seatbelt. I think it goes more to it was brought up, it was It's not a prohibited act, it's a permissible act in a prohibited manner. And that's what we have here. We have a permissive act in a prohibited manner. We don't, and this is another thing, and I go to causation too, because even if we have this prohibited act and we're talking about whether or not it's express and all these things, we're going back to what I was talking about before. We can talk all day long about whether or not he committed a prohibited act, but there is no evidence whatsoever that even if we assume he did, that it was the cause of the injury. There's a reason that there is the seatbelt gag rule when we're in, say, district court, we're before a jury, and we're talking about a car accident. And, you don't even need to do motions in limine on seatbelt use, because seatbelt use is not allowed. It's not allowed because it's impossible, or it's really been deemed improbable and likely impossible to state that had someone been wearing a seatbelt, an injury would have been avoided or reduced. And that's why the rule is in place.
Oh, I have a couple questions. So at least I understand from reading the transcript, Mr. English has testified that he was wearing the lap belt, but he had moved, as you indicated, the shoulder strap. Is that a correct understanding?
That's correct.
And then I've looked at the video and I've seen the photographs depicting a tie rod in those. Which tie rod? Because is it the front tie rod, front rear, left front?
Well, that's difficult to determine, because when those photographs you're seeing, I took, we went there to take those photographs. We had provided a spoliation letter saying, please don't change or alter this vehicle in any shape or form. And when I got there, the tie rod had been fixed. So I can't specifically answer that. Although it is a fact of this case. It is a piece of evidence that the way he was injured was the tie rod snapped. I believe it was, from what I can recall, it was in the back, one of the back, right or left, causing the vehicle to fling sideways in an instant and causing the injury. So.
Mr. Nelson, do you feel that that Judge Bateson was required to use, you said a kind of a 6-factor test. I think it was just more 6 factors, but is the judge required to use the factors set forth in Hassan?
No, I mean, I don't think he is at all. I believe he used Ball versus Mancino was a case that I in fact had cited to me in an appellate argument that I made on a prohibited act case that was appealed against me before this one. And in reading the appellate court argument, that was the case that was cited concerning prohibited act, not a 6-part test. This court could say, we'll go back to that. This court could say, the compensation judge should have used a 6-part test. I could go through the 6-part test right now and it would be a failure. But
and I didn't mean for you to do that, but my question was, do you read Hassan as each one of these must be discussed by the judge, or do you see it more as these are things to consider?
I see it more as these are things to consider. And I think what trumps those 6 pieces or those 6 questions is listed later. We can talk about this until we're blue in the face. But if this prohibited act, which we've determined through the 6, is not the cause of the injury, then let's not waste our time on the 6. And I think that's what, the compensation judge really looked at the evidence and said, there is no evidence here whatsoever that indicates that this assumed prohibited act was the cause of the injury. So I'm not going to waste time. And those are just factors to be considered.
And I'd like to move to the average due wage issue. Do you agree that your client was on call?
Well, I believe he testified he was on call.
So then my next question is, do you feel that an injured worker can be an on-call worker and a seasonal worker?
Well, absolutely. So I think mixing two different areas of law. And I stated that in my brief. The on-call portion goes to whether someone's regularly employed. And then if they are determined to be regularly employed, whether they're on call or not, then are they seasonal? Because if they're not regularly employed, then their wages don't count when we're talking about, sub 18, when you have two areas of law. And so here, the judge determined and stated specifically that Mr. English was regularly employed at both HireQuest and at Reliable. And that's a fact determination. It has to be clearly erroneous, and it's not. Now, to be regularly employed, it has to be a situation where you are providing a service to the employer. You have done it in the past. And I think a lot of the cases really point to, can we look to the future? Is there enough in the past that we can look to the future and say there is going to be a continued obligation to the employer to provide essential services? We have history from 2017, 2018, 2019. Now, they'd say that's in the past, but he was hired in the exact same role that he had in those years. And so we look to the future, and we have, and this is a case where I don't think any major sways in the law should happen because it's a unique situation. He was injured really very shortly after he started to work, passing the drug test on the 11th, I believe, and then starting to work in that capacity that he always worked in before. And he, like I said, he testified, when it snows, I'm working. One, I guess, could say, as may have been asked, well, how do we know if it's going to snow in the future? He's only on call when it snows, or he's on call at the whim of the employer. He's not on call at the whim of the employer because he's the only option to come in and work. He's on call at the whim of nature. And that is exactly what a seasonal employee is. They work because, and I think a lot of times people are in this case, it may be, and I'm assuming it may be that we're having a hard time wrapping our head around the fact that he works when the weather's bad. But normally seasonal people work when the weather's good. Right now I have a case where I have a blacktop layer. He can work when it's sunny and 80 degrees, but he can't work when it's too windy. He can't work when it's raining. He can't work when there's frost in the morning. So quote unquote bad weather, he can't work. Here, my client's just the opposite. Mr. English works when the weather's bad. He works when it's snowing, okay? And he does a lot of tasks related to that. Cleans the snow, pushes it to the side, fills the skid loaders, removes the snow, all these tasks related to quote unquote bad weather. And yet we're sitting here asking, is this a seasonal employment job? It is. All the statute says is whether or not the employment or you work in an industry that's affected by seasonal conditions. There is no caveat or cutout for if someone works, a 9-to-5 job but can't when it's raining, as opposed to someone who works when it's snowing or when they need to come in. Again, and I will repeat.
Sorry to interrupt you.
Yeah.
Can you address what I'll call kind of the fairness issue brought up by Ms. Huff? It just doesn't seem fair that his wage should be, I'll use the word inflated, almost doubled because of the statute.
Yeah.
If you can address that.
Well, and in researching these cases, and I think you guys probably know as well in reading these cases, it's the Palkowski case that says, this is the situation, okay? We know that if he had only worked one day clearing snow before the date of injury, okay, and 5 times his daily wage was, $900 or $600 or $800, we wouldn't even be here right now. We probably wouldn't even be before you. But that's the nature, that's what happens. It's nature is irregular or it is unpredictable. And there's no way to know whether or not, had he not been injured, he would have worked 3 days a week clearing snow going forward at sometimes 17 hours a day, or he wouldn't have worked ever again. We don't know that. But that's the point of the statute. You take the unpredictability of nature away, and you take you calculate a daily wage and you multiply it by 5. And it's statutory. And it's been found to be unfair and appealed as unfair for as long as anybody has ever known, and yet that's the statute. If it is something that is completely unfair or it comes up too often, then the legislature needs to change it.
I'd like to ask you about MMI.
Mhm.
Dr. Laura says, I think it was at the end of 2022, something along the lines of, this is about as good as it's going to get. About a year later, Dr. Laura says, well, there's some room for improvement. It's kind of vague about it, but, says that. And Ms. Tuft is certainly correct that MMI doesn't mean end of medical care. Your client's still entitled to medical care. So despite the fact that some additional medical care is being recommended, how is your client not at MMI just because Dr. Laura says there might be room for improvement, or maybe that's good enough? I mean, I don't know.
Yeah, I mean, as you know, the compensation judge can choose which physician they believe. And Dr. Laura had indicated that, I don't think she wanted to give up on him, if I'm going to be fair.
Sure.
Okay. And I think he had come to a point where it was looking pretty grim concerning his injury and perhaps his ability to work and whether or not his condition was improving. But she said, I think physical therapy will help improve your condition. So you should go through that. We should also not lose sight of the fact that on top of that, there is another accepted injury, okay, an injury found to be the ulcer, and a scope was recommended to find out if the healing that the MNGI had hoped was continuing to do so, and then to dictate more care after that. And really imaging, and that's a surgical procedure. It's not just imaging, right? But imaging can be found to be not at MMI if you need imaging in order to then dictate further care. And so, one could argue, look, he'd done PT before. How much PT is the guy going to do, right? I would say, Dr. Laura said, I think there's room for improvement, and that's why I'm recommending that. Okay. Now that would be
You're now at your time. If you can wrap it up in 10 seconds.
just to finish that point. I think that if I was hanging on that portion alone, really, it's pretty rare to overturn a judge on which doctor they choose. Okay, it's not like it hasn't happened. It's not clearly erroneous, but we still do have the scope issue that they need to look at what's going on down there to make sure that it's healing. Those are both admitted injuries found to be causally related, and so that was care that was recommended, reasonable, necessary, and related care that was recommended that would defeat MMI, according to the judge.
Thank you both.
Thank you.
We are adjourned. We'll have a decision out in 90 days. Thank you to both counsel again, because it was very helpful to have you here this morning.
What is that? We are all done. Citizen video. Dang it, I fed the meter too much.